Good morning. And I am honored to be here to speak with you today. I've been trying to be prayerful for the last few days, hoping that my words would bring hope and charity to our daily lives, given the fact that so much what we hear from our leaders is invectives that appeal to our fears and prejudices. I think we need some hope and charity. I've set this presentation up into like 4 steps. The first is just a short overview of Presumption of Innocence, because my presentation today is entitled Preserving the Presumption of Innocence, the Battle Over the Use of Pretrial Risk Assessment Tools. Pretty wonky title, I know it is. But I wanted to start with the idea of the origins of presumption of innocence and how it relates to bail, and how that is being eroded by a number of things, including the new pretrial risk assessment tools, and end with some last steps or some next steps that we can take. So I promise to try not to be too boring with a lot of legal stuff. But we begin with a brief discussion about the origins of presumption of innocence, which is considered to be a very important part of our criminal justice system. And our criminal justice system was borrowed from the English common law. So it might surprise you to find out that the presumption of innocence is not was not originally found in English common law. It was borrowed from the French Roman law and adopted into English common law near the end of the 12th century. And it was adopted by reform-minded jurists who were trying to move away from the proof practice of that era. And it involved what was called a test or an ordeal of proof. Ordeal of proof was like a medieval way of proving guilt or innocence. It required you to subject yourself to these tests. For example, there was a boiling hot water test where an accused was required to stick their hand into boiling water and to retrieve a stone. And after the stone was retrieved, the injured hand was wrapped. And after 3 days, they would unwrap the hand to see if it was healing or blistering. If it was blistering, you were guilty. And if it was healing, you were innocent. So that is how people proved their innocence under English common law in the 12th century. So these reform-minded jurists decided, we want to move away from that. We want to incorporate Roman law, which involved a process of proof that didn't include these types of torturous, horrible practices. But these practices had been embraced by the people, by the church, by the rulers, and they knew that it would be difficult, it wouldn't be easy to make people switch, to move away from these sort of pagan rituals and practices. And so they came up with a wonderful way to come up with a compelling argument to move towards this Roman law. They looked at some of the principles that were contained in Roman law, including the presumption of innocence, and said that this was not just a product of community norms, like most common law, but it really came from God. These were divine principles found in the Bible. And they said the presumption of innocence came from the book of Genesis. And it began when God said to Adam, after he found out he had eaten from the tree of life, and he confronted him. He asked him, even though he's omnipotent, what did you do? And Adam was given an opportunity to explain himself. And so these reform-minded jurists said this presumption of innocence that God gave to Adam is something that everyone, all people, should be entitled to. And so they said the Roman law and these principles, including the presumption of innocence, was divine law. And over time, they managed to convince people, including the church and rulers, that not only did this apply to common people, but it applied to rulers and powerful people. Everyone had to submit to this concept of presumption of innocence. So if you flash forward a couple of centuries, we end up having this same presumption, which transferred from Europe to America through the colonies, and ultimately it was recognized as being an integral part of our system in 1894 in a case called Coffin v. U.S., where we embraced this idea of presumption of innocence being an integral part of the Anglo-American jurisprudence. Well, so what does presumption of innocence have to do with bail, this idea of bail? Well, presumption, embodied in this concept of presumption of innocence, is this notion that freedom matters. Individual freedom matters. Bail is designed to allow people accused of crimes, only accused, they're not convicted, accused of crimes, the freedom to remain free, to prepare their cases, to defend themselves against these accusations of wrongdoing. So bail is rooted in the idea of presumption of innocence because innocent people should remain free. They're entitled to be free. And the other thing the presumption of innocence does that's very important, it shields people accused of crimes from additional punishment simply because they've been accused of a crime. So the presumption of innocence and bail work hand in hand. And the leading case on this is a case called U.S. v. Boyle. The court said that the presumption of innocence and bail stands for this very simple proposition, that a person accused of a crime is entitled to the same level of freedom and to the same respect as anyone else in their community. That being accused of a crime does not make you any less worthy of respect, any less worthy of freedom. So what's happened to this presumption of innocence and its relationship to bail? Well, over time, we have moved away from believing that people accused of crimes are, in fact, innocent. We begin to treat them as though they're guilty. And we did this by using bail not as a way to ensure that a person shows up in court, because originally that's what bail was designed to do. Judges impose some type of restrictions on a person's freedom to leave, to go out, to be released from jail, with the idea that these restrictions would, one, require you to come back or force you or compel you to come back, and also hopefully discourage you from committing other crimes. That's what bail was supposed to be. But over time, we have begun to use bail as a form of punishment. We've created more and more restrictions, placed more and more restrictions on people's liberties, pretrial liberties, preventing them from being free to help defend themselves against wrongdoing, allowing them to sit in jail. What we've also done is we've introduced this idea of money bail. Money bail is a sum of money that people who have been charged with a crime are required to post in order to be released from custody. Well, then that sounds like it's a simple matter. But see, in this country, we've turned money bail into a business. We now have bail bonds people who make their living off of poor people who don't have the resources themselves, but who then have to hire them or secure their services by giving property or a percentage of money, which they don't get back because there's a fee charge. And the bail bondsman then posts the bonds for those individuals. And you've seen, Dog the Bounty Hunter. Well, bounty hunters work for bail bonds people who are there trying to collect money from people who don't show up in court. So there's a whole big industry that's built around the idea of poor people being held in custody. And that's caused a corruption in our system, a lot of disparities between Black, white, and Latino defendants when it comes to arrests and detentions. For example, in 2013, there was a study that found that there was about 62% of the people in our jails, which is where people who are charged with crimes go, prison is for people who've been convicted of crimes. 62% of the people in our jails in the U.S. were there simply because of pretrial convictions, pretrial detention, meaning they were just there because they were poor. 62% of the people in jails throughout this country were there because they were poor. And of that 62%, 50% of those were Black and Latinos, even though they only represent 29% of the total U.S. population. So as a result of money bail and the for-profit money bail industry, we've seen this incredible disparity in who is sitting in jail. If you go down to the Pima County Jail today, you're going to see that disparity for yourself. Large numbers of people in our jail, 60 to 70% of them in our jail, are there because they're poor. And most of those people are going to be brown, Black, indigenous, or othered, meaning the LGBTQ, homeless, mentally ill. These are the people who sit in our jails. And so in 2017, the Tucson Second Chance Community Bail Fund was established. It was established for the sole purpose of trying to liberate people who are sitting in our jail simply because they're poor. We take donations from people in our community and use those donations to post bail. And although our bail amount is only $2,300 to $3,000, we have been able to help a few people. And what we've been told over and over again is that a lot of them thought they would never get out. They were desperate to get out because we know statistically what happens to people if you're in jail for even a short period of time. People lose jobs. They are kicked out of houses. And in fact, in apartments and in public housing, this is grounds for to have you evicted, to bar you from returning to your apartment or to your house. They lose their children if they're single parents. I say constantly to people that the idea of separating families and children did not begin at the border. It expanded from our communities to the border. We have lots of families sitting in our jails right now who are separated from their spouses, from their children. And there is no hue and cry about that. So what's happened is that because of the bail fund reform movement, if you want to call it that, and there has been a movement, and the Tucson Second Chance Community Bail Fund is part of this national movement to end cash bail, there has been a sort of gradual awakening of the communities, of the public, to the fact that this is an unfair system. And there have been some great strides made. A number of states like Montana, New Mexico, and New Jersey have actually ended money bail. But then we have states like California, which said last week that they passed this no bail, end of bail, cash money bail, bill SB 10, and there's a lot of celebration. But the people, most of the activists who used to support that bill, turned against it because they saw that what the state really did was they did a shell game. They said, oh, we're going to end money bail, but now we're going to use pretrial risk assessment tools, which are based on algorithms, to determine who should be released. And I say pretrial risk assessment tools and algorithms, think of Tom Cruise in the Minority Report, pre-crime. This notion that we can predict who's going to commit crimes based on their prior history, the choices they've made in their life. So we can predict criminality, who's likely not to show up in court, who may be a risk to public safety based on these information sheets about your prior history. But what we know about algorithms is that they tend to be very biased, that depending on what kinds of information you ask, those results can be skewed in such a way that you end up capturing the same people that have always been incarcerated. And that's what we see happening. We see pretrial risk assessments being used in such a way that the same people who were always incarcerated are now being incarcerated for indefinite periods of time. So at the end of July, the Tucson Second Chance Bail Fund joined over 100 civil rights and human rights groups throughout this country to condemn this trend towards using risk assessment tools. And some of the key points that we point out about these risk assessments, one is that a lot of the companies that create or develop these tools are not transparent. They do not want to have independent parties come in and examine the design or audit the calibration or the test results. And we believe that you should not allow the state to use an instrument that takes away people's liberty without allowing the community and interested parties to examine that instrument to make sure that it is being applied fairly, that it is based on hard science. Another objection to the pretrial risk assessments is that these instruments talk about probability of committing crime, not certainty. So you can lose your freedom based on the probability that you may commit a crime. They don't know what will happen between a poor decision, and a criminal action. Because we know that in life, things happen. People encounter folks who love them. They make different choices. They learn from mistakes. And so what started out looking pretty dim can turn into a very different ending for people. So if we lock people into this notion that your choices are intractable and that there's a straight line from one bad decision to crime, then we have become a really scary, Minority Report type of society where we can start They're probably going into elementary school and doing risk assessments on childhood trauma and saying which of these kids are likely to commit crimes, because we know that the majority of people sitting in prisons have childhood trauma. So why not just identify them in elementary school, right? So we are, and the other important piece of this is that they also are rooted in racism. If you look at I was reading an article about the racism of algorithms. One of the things they pointed out is that, like, if you did the Google facial recognition app, and you put in black people or black woman or black man, then pictures of gorillas would come up. And they kept saying, where did that come from? Why are you getting pictures of gorillas? Well, it's because the people who design these programs have implicit bias. And these ideas, although individually don't make a big difference, but when you populate that stuff, all of a sudden this data starts to take shape in a form that implies a sort of racism that's not apparent, but it is part of the data collection process. So if I asked you questions that are designed to target people who are poor, that will disproportionately reflect negatively on people whose parents, who maybe came from a single parent home, who've been arrested multiple times because they live in a community that's over-policed. These are people who are going to end up locked up. And these are the people who we know have traditionally been locked up. And so all these human rights and civil rights groups are saying we as a society cannot continue to lock up and criminalize whole classes of people. It's unsustainable, it's immoral. It is wrong. So, what are the next steps? Well, the Just and Second Chance Bail Fund is a bail fund. We obviously can always use donations, which you can make if you choose to do that. But we're also interested in expanding the conversation from just bail to the larger question of the broken justice system and mass incarceration. We started what we call a Bail Plus program. The Bail Plus program that we are working on right now is based on a program called Court Watch. There are Court Watch programs throughout the United States: New Orleans, Brooklyn, Chicago, San Francisco. A lot of major metropolitan areas use Court Watch systems or programs as a way to bring the community into their courthouse, because courts are a reflection of community values. And what our court looks like and how it operates, even though there's a uniform system that is in place, but it really is an extension of this community's values. So it will operate differently in a lot of ways, because the judges and the prosecutors and the defense attorneys, any of the people coming into that community share certain views and values. So it looks different than people in Phoenix, or it looks different than the people courthouse in Nogales. And having practiced here for a lot of years, I'll say 40 years, I can say that that's true. Each community is very individual. And it's important for people in a community to know what kind of justice is being administered in their name. And unfortunately, that's not what happens. Our community is run by insiders. And the people who should care, the people who are ultimately responsible for it, are very passive. They don't go to court unless they know someone who's maybe had some issues, or you're going to a civil proceeding. So we are trying to, through the Court Watch program, trying to get people to come in and see for themselves how our courts operate. Sit through an initial appearance, see what kind of bail is being imposed, who's being held, and under what conditions of release people are being allowed to get out of jail. We want you to go and listen to a sentencing procedure, sentencing hearing, so that you can actually listen to the type of policies that the prosecutors are using in order to get people to do changes of plea. Are they overcharging people with drug offenses? And I can say for our community that that is our county attorney, current county attorney, has a very bad reputation for overcharging people. And in fact, we had an unusual thing happen with the grand jury here. We had a grand jury nullification, which is very rare, which means that our grand jury, made of people in our community like you, refused to indict anyone on any drug charge brought before them, because they said, we saw that you, prosecutor, are charging people for crimes that should not, for felonies that shouldn't be felonies. You're ramming people into a prison sentence. And these community people said, no, We will not do it. So, I love that story because it's such a marvelous statement of what people can do who care, who are awakened, who are conscious of what's going on in their jails and in their courts. So Court Watch is an opportunity to get you to engage and see what's going on in the courthouse and to hold people accountable, because you get to vote on which judges are going to be retained. And you don't have to rely on a judicial committee's report. You, as a member of the community, can go into court and say, I've watched these judges, and I know which ones, really express the type of things that we care about, who are fair-minded. You also have the right to, you're going to get to vote for the county attorney. Do we want that prosecutor, or do we want a prosecutor who has a more progressive agenda? You get to make those choices, but you need to make those choices from a place of being informed. And I do have some volunteer sheets that I think they will present to you at some later point today. And I hope that you will consider becoming a volunteer for our Court Watch program. You will go through some training, and we will ask you to not only sit in and learn, but also to help us collect data so that we can make a stronger case on behalf of the people in the community who are being negatively impacted by this, our broken criminal justice system. So I'm going to end with a poem, and it's a poem by a very famous poet, Paul Laurence Dunbar, who was born in 1872. His parents were slaves, and their stories about slavery influenced a lot of his early writings, a lot of his writings throughout his life. He died early, I want to say. And this poem, he speaks about, with such beauty, about why a caged bird sings. Okay, it's called Sympathy. And excuse me, I have problems with my vision, so I have to hold this a little strange, but hopefully the words will be okay. I know where the caged bird feels at last, at last. When the sun is bright on the upward slopes, where the wind stirs soft through the springing grass, and the river flows like a stream of glass. When the first bird sings and the first bud opes, and the faint perfume from its chalice steals, I know what the caged bird feels. I know why the caged bird beats his wing till its blood is red on the caged bars. For he must fly back to his perch and cling when he fain would be on the bough a swing. And the pain still throbs and the old scars, and they pulse again with a keener sting. I know why the caged bird sings. I know why the caged bird sings on me when his wing is bruised and his bosom sore, when he beats his bars and would be free. It is not a carol of joy or glee, but a prayer that he sends from his heart's deep core, but a plea then upward to heaven he flings. I know why the caged bird sings. Thank you.
Please stand right.